Hello everyone, welcome to Adamya Academy YouTube classes. Till yesterday we have discussed about the concepts of right as well as duties and also some concepts related to ownership. So today we will be continuing our discussion on ownership as well as we will take a look into what do you mean by possession, as well as we will do the questions related to legal rights and duties, ownership and possession. So let's start. Concept of ownership in jurisprudence. Ownership is a basic and fundamental jurisprudential concept. As a concept of jurisprudence, it has various views to various people. So first let us try to understand what is ownership and what is possession. Let us consider that I have a property. It means that I have bought the property for 20 lakh rupees from a third party, and that person has lended me the property and I can enjoy the property as I want. So in this case I am the owner of the property because I have signed the agreement and I have taken the keys of the property. But consider a situation in which I have taken a house on rent and is living in these properties. So in this case I am the lessee because I am actually availing the property as a possession and not with regard to the ownership. So I just have the right of possession in that property and not ownership, because at any point of time the lessor can tell me to vacate the property if I have not paid the bill or if the time has lapsed. So this is the basic difference between ownership and possession. Ownership has a special place both in legal and social interest of our society. Not only it is seen in our books of jurisprudence, it now appears in our legal system as would be shown in this work. So this means that ownership is not a concept which is just written in books. It is actually applied in the present scenario as well. So let us consider some examples. Let us consider that I have a property in which I grow crops. So I am the owner of the property because I bought the property, and the produce which the land gives me is sole my produce. So I can use the produce, I can use the land actually because I am the owner of that land. So let us consider another example in which I have a property which is named as A property, and some person B, who is the neighbor of mine, actually comes without my prior permission and gets into the house and tries to without any permission. So in this case B will be considered as trespasser because I am the owner of the property, and without my prior permission if anybody comes and enjoys the property, then he or she will be considered as a trespasser. But it is essential that I have to prove that I am the actual owner of the property with regard to the, I can show them papers, or I can actually tell them that I have given so much money to buy this property and therefore I am the owner of the property. Ownership appears in our legal system when we look at the claims, privileges, powers and immunities with regard to the things we own. So we can have certain privileges as well as claims with regard to ownership. For example, I can give the property which I own on rent, and also I have certain privileges. That it means that I can enjoy my property, I can do some cultural events on my property, or I can use it as a business place. So it depends on me. So I have the privilege, I have the powers related to that property. For example, the one who owns a house has the claims, powers, privilege over it. It will be shown in this work that ownership is not such an abstract concept only found in our books, but it is seen in our day-to-day activities as humans, like how I have told you examples of trespass and also the examples related to privilege. Definition. Ownership is defined by the Black's Law Dictionary as the collection of rights allowing one to use and enjoy property. So Black's Law Dictionary is a very famous dictionary which actually gives us basic definitions related to law. So what Black's Law Dictionary have to tell about ownership? So it tells that these are rights allowing one to use and enjoy property. So what is ownership? Ownership is a kind of right which allows us to use and enjoy the property as we want. what Salmon has to tell in the book Salmon on Jurisprudence. So we have discussed when we were discussing about the various proponents of various schools. So Salmon was a proponent of an analytical school of jurisprudence who has written a very famous book known as Salmon Book on Jurisprudence, which is actually the textbook in the present scenario in many courses. So what Salmon has to write in his book Salmon on Jurisprudence: ownership as the relationship between a person and an object which forms forming the subject matter of his ownership. It consists in a complex of rights, all of which are rights in rem, being good against the entire world and not merely specific persons. So Salmon considers that ownership is the relationship between the object and the owner. Let us take an example. Let us consider that this pen, I am the owner of this pen. So there is a relationship between pen and me because I have bought the pen, and I have bought the pen afresh without it having a previous owner. So I am a fresh owner and I am the absolute owner of this pen. So it is the relationship between subject or object and owner. And he also discusses about right in rem. So we have discussed what is right in rem. Right in rem is available against the whole society. It means that this pen should not be stolen by anybody in the society. It is not available to just between, this right is not between just two parties or between X number of parties, but this right is available against the whole society. Is what is right in rem. John Austin in his book Jurisprudence II gave his own view on the definition or concept of ownership as right, indefinite in point of user, unrestricted in point of disposition, and unlimited in point of duration over a determinate thing. So indefinite, it means that I am the owner of a property. Let's consider X property. Then I am the owner of the property for whole life. No one can snatch away the property from me until I want that I should give the property as a gift or in a will. So I am the indefinite owner of that property. Similarly, it should be unrestricted. It means that I can do whatever I want in that property. It means that I can open a business school in that property, or I can use it as a commercial hub, or I can convert it into a museum, or I can give it on a rent, or I can allow some NGO to work in it. So I can use it as I want because I am the owner of that property, and therefore I am the unrestricted user to that property. And unlimited in point of duration over a determinate thing. What does unlimited mean? Which I have told you that I can use the property till the time I remain the owner of that property, or till the time I extend my ownership. And what Reginald W.M. Dias has to tell about ownership, his own view on the concept of ownership. After studying Salmon and other jurisprudential scholars, Dias came to the conclusion that a person is owner of a thing when his interests will outlast the interest of other persons in the same thing. So if I am the owner of a property, let's assume X, then I have the absolute interest in that property, or my interest in the property is supreme, and all the interests which other people might have in my property are all subordinate interests. So if a person comes on a rent or as a lessee in my property, then my interest will be superior because I am the owner, and the interest of the lessee will be subordinate. So this differentiates between ownership and possession. Dr. C.C. Vigvi in his book defined ownership in a crystal clear way, and his definition cuts across all the common views on ownership. Dr. Vigvi's view on ownership is that ownership is a bundle of right and privileges exclusive in character and indefinite in point of time. So according to him, ownership is a bundle of rights. How is ownership a bundle of rights? Ownership gives us many rights and many privileges associated with it. As to, we can use it for indefinite period of time, we can use it unrestrictedly, and we can also use it as we want for the any specific person which is not illegal. So we can use it for unlimited time, indefinite purpose, and unrestricted. Learned jurist Nicky Toby, JC, as he was then, defined ownership in Abraham versus Olorunfuni as a totality or bundle of rights of the owner over and above every other person on a thing. So he defined that owner is the person who has the maximum interest in the property, and compared to other persons who might have some interest in that property. The conclusion: Salmon view on ownership as being indeterminate in duration and residuary in nature. Dyer sees ownership as an outlasting interest on right or object. Austin holds his own view on ownership as a strong right a person has over an object which is greater than rights of others. Dr. Vegui then gives us a definition of ownership and takes us into cognizance of common traits of ownership in various definitions by different scholars, putting it as a right or a privilege. Who is the owner? The concept of ownership has been clearly spelled out above through the various definitions of different scholars. Now it is time to know who his owner is. It is only logical that where there is ownership, an owner must be present. So when we are talking or discussing about ownership, we should actually know who the owner is. And when we are discussing about ownership, it is of course practical that a person named owner will be there in ownership. An owner is the one who is not subject to the right of another person over property, because as a matter of law and fact there is no other party's right over the property that is higher than his. This we have discussed already. One wouldn't be wrong describing an owner as the alpha and omega of his property. It means that he is the sole or absolute person who has the charge of that property. Essentials of ownership. It is definite to the user, no limitation. He who declares himself as owner over a property or right has no limitation whatsoever over which he owns, like he can do many jobs on that property. Ownership is unrestricted at the point of alienation or disposition. An owner has unrivaled power to give out what he owns. No other higher authority or power can rival that of the owner to dispose of what he owns. Let us consider that there is a property named A, and there are 4 sections in that property, and 4 persons have got the property in inheritance by the will of the father. So these all 4 persons are siblings. X, Y, Z and B are the siblings of the property A. So in this case, if X wants that he should sell the part of his property, then he can of course do that. He can sell that part of the property to either Y, Z or B, or to any third party which he deems fit can buy his property. So he can dispose of the property because he is the owner of the property. A right to possess that which he owns. Ownership affords the owner with the right to enter into possession or possess that what he owns. So if I am the owner of a certain property, I have the right, which is inbuilt right, to possess this property as well. It depends on me that when I want to use that right of possession. It can happen that I am living in India and my property is in America, so it can happen that I don't go to America so often and I don't use that property, or I don't actually enjoy the possession of that property, but it does not mean that I am not the owner of that property. Possession comes with ownership. So I can possess the property which I own. An owner can part with several parts of that which he owns and will still be the owner of the remaining whole. Does not matter what his section he parts with, he still has ownership of the remaining part as long as he has not parted, alienated or disposed of that which he owns. It means that I have a property, let us consider A property, and I have made different parts with respect to that property. Let us consider I have made 4 parts, in which one part I have given as a shop, second part I have rented as hotel, third part I have given as playground, and fourth part I have written as office, and fifth is residential. So if I want to sell this part of land which has shop in it, so I can obviously do that because I am the owner of that property. And when I sell this part of land, it does not mean that I have sold whole the part of the land. It only means that I have sold a part of the land and I am not the owner of that land now. But at the same time I am owner of the remaining part of the land on which I have residential residence, office, playground as well as hotel. So only the part of the land ownership has gone. Types of ownership: corporeal and incorporeal ownership, sole ownership and co-ownership, legal and equitable ownership, trust-owned ownership and beneficial ownership, absolute ownership and limited ownership, vested and contingent ownership. So first we will look into corporeal and incorporeal ownership. Corporeal ownership refers to ownership of a physical object, that which can be perceived by senses. Incorporeal ownership is ownership of a right which does not exist in a physical state, that which cannot be perceived. Example, intellectual property. So you all might be thinking that what is the difference between corporeal and incorporeal. So corporeal, the word itself suggests that it has come from a word corpus, which means body. So it has some physical existence. It means that the property or the thing on which the question of ownership is arising can be perceived by senses. It means that by the sense of touch, smell, taste or any of the senses we can actually perceive that there is a property. So that property will be considered, or the ownership of that property will be corporeal ownership. On the other hand, if we have some property which can't be perceived by senses, for example intellectual property rights, law of patents, copyright, etc. So these are the rights which can't be perceived. We can't say that IPR can be touched. It can't be. So patents right, copyright right, etc. are incorporeal rights. Now next is sole ownership and co-ownership. Sole ownership refers to that which one individual owns, whereas in more than one person owning a property, then it is co-ownership. So let us consider examples. If I have taken a 1 BHK flat in a different city at the cost of 20 lakhs and I have paid the money and has got the key and have done registration related to that property, then I am the owner and the sole owner of that property because I have only paid for that property. But consider a situation of partnership, a flat system, or company. In the company, board of directors have invested in different ways. Some have invested by giving goodwill. Some have invested by investing the money. So consider that A and B have invested by investing the money. So they both are the co-owners of company along with other members, like other directors, like the directors who have invested in goodwill. So this is the concept of co-ownership. It means that not a single person is the owner of the property, but many persons at stretch are owner of the property. This concept is nowadays followed very largely in the present society. So we can see different systems which are there in our society nowadays. So people are trying that they should have houses in a flat system so that they are able to enter into partnership with a third party and by this they will actually pool the resources or pool the money which they have and buy the land as the co-owner of the land. Legal ownership and equitable ownership. Simply put, legal ownership is ownership based on common law. Equitable ownership comes with equity and is based on principles of equity. So, legal ownership is the ownership which comes from common law. It means that whatever constitution or the Indian Penal Code or the Criminal Procedure Code or family law has told us about law is what is, and what the concept of ownership in those laws is considered to be legal ownership. And what is equitable ownership? Equitable ownership comes from the principles of good conscience, principles of natural justice, common conscience, etc. And fourth is trust ownership and beneficial ownership. Trust ownership is between two people known as the trustee and beneficiary. The trustee is merely an agent upon whom the law has placed duty to administer the rights over the property for a beneficiary. The trustee is called upon to use his ownership for the good of the beneficiary. Beneficiary ownership deals with the beneficiary of a trust who has the full enjoyment and complete ownership of his property. So let us assume that a father has written a trust in the name of a beneficiary, which is his son, who is at the age of 10 years and he does not have the capacity to be the owner of that trust. So till he does not have the capacity to be the owner, he will be considered as beneficiary. So guardian will be appointed to take care of that property on the behalf of the beneficiary. So in this case, till the beneficiary does not attain age in which he will be deemed to have the capacity to become the owner of the property, he will be considered as beneficiary only. So when he attains a age of majority, or let us assume he becomes he has now age of 19 years, so in this case the ownership will automatically be transferred to the beneficiary. So this is the relation of trustee and beneficiary in trust. Absolute ownership and limited ownership. Absolute ownership is when possession, enjoyment, disposal are complete and vested without restrictions, all the rights to the exclusion of all. Limited ownership occurs when there are limitations on the user, example in terms of disposal rights. So let us consider that the example which I have taken previously also, that let us consider I have an X property and I have taken the property in lieu of 20 lakh rupees, and I have actually bought the property, and now I am the actual owner of the property. So I am the absolute owner of the property because I only have bought the property. I can also be told as the sole owner of the property. But consider a situation in which I don't have 20 lakh rupees. So my sister and I both have bought the property. She has invested 10 lakh rupees and I have also invested 10 lakh rupees. So in this case, both will be considered as co-owners, and if I want to sell the property which we have commonly bought, I can't sell that without taking a prior permission from my sister, because she also has interest in the same part of the property. So I have limited interest in that property and I can't dispose of at my will. Vested ownership and contingent ownership. Vested ownership is having perfect right, enjoyment and privilege over a future property, ownership of a chattel. Ownership is said to be contingent when it is capable of being perfect after the fulfillment of certain conditions. So vested ownership is the ownership which is bought when a person actually enters into an agreement and do all the necessary requirements of the agreement and has bought the property. But what is the case in contingent interest? In contingent interest, we can take the example to actually interpret what is contingent interest. Let us consider that a father has given his property A to a son by lieu of will. So father has given the property to son in lieu of will. So this is an example of vested interest, vested ownership. But consider a different situation in which father in his will has written that his son will get the property only in the case if the son becomes a doctor or an engineer or has this much income. So in that case, a contingency or a condition is attached with the ownership of the property. So in this case, the son has the contingent ownership of that property. Subject matter of ownership. Normally ownership implies the following: the right to manage, the right to possess, the right to capital, and the right to income. So the owner has the right to manage his property. The owner has the right that he can derive capital from that property or derive income from that property. He can invest in that property so as to get large sums of money in future, and also he has right to possess that property. Modes of acquisition of ownership. Original acquisition. This ownership takes place when ownership is acquired by some personal act on the part of acquirer. It can be in three ways. Absolute, when a thing is acquired with no previous owner or being made into the new thing. For example, let us consider that I have bought this pen, and I bought it. For example, I have paid rupees 200 to buy this pen, and in the case this pen I have bought from an online site, and this pen is a fresh item and it is not used previously. So in this case, I am the absolute owner of this pen, and also I have the original acquisition to this pen because no previous owner is present in this case. No previous owner. So second is extinctive acquisition of ownership. This when a person by some act on his part extinguishes the ownership of the previous owner and acquires that ownership himself. Example, ownership by prescription. So what do you mean by ownership by prescription? Let us consider an example in which I have paid the money for one pen, but the delivery boy has delivered me 2 pens instead. So I can extend my right. I can extend my right and give other pen to my friend, and the friend can be owner of the other pen. So in this case, I have prescribed my right of that pen to my friend. So this is acquisition by extinction of my right. SSU. This is called accessory acquisition because when the ownership of property is acquired by way of accession to some existing property, example, produce of lands or animals or fruits or trees. Let us consider examples related to it. Let us consider that I have bought a cow, and thus that cow has given a child. So in this case, what then will I have the right over that also? So on that bachla I will also have the right because I am the absolute owner of the cow. In similar fashion, the produce which I get from that cow will also be under my ownership. So another example is that I have a plot of land on which I do agriculture. So when I sow the crops, and when the crops are harvested, and when it is sold, then should I receive the money of that crops or not? Of course yes, because I am the owner of that land, and therefore I am also owner of the produce which the land gives. Derivative acquisition. When ownership is derived from a previous owner, it is called derivative. It takes place when ownership is acquired by inheritance or gift or purchase. So when a father gives his property by will to his children, then in this case it is the ownership acquired, or it is the derived ownership, because father was previously the owner of that property and he has given that property to a next owner, which is a second owner, which are the children of that father. So this can be the example. Other example can be that if I have this pen and I have bought this pen and I think that I should give that pen to my friend, so I can gift that pen and without any remuneration. So this is also example of derivative ownership. Now we will look at concept of possession. Pollock says that having physical power over a thing which establishes possession. Salmon, the possession of a material item is the proceeding with the existence of a case to its select utilization. This possession includes two things. So according to Pollock, the possession is having the physical power over the object. Let us consider this, that if I am the owner of this pen, I should also be able to physically possess this pen. So this physical possession or physical control over this pen is what is possession. So according to Salmon, the claim of selective client and the conscious or genuine exercise of this guarantee, for example, physical command over it. The previous is a mental element called animus possession, and the last is physical element called corpus possessendi. So it means that I should have the intention to possess this pen, and also I should do an act to possess this pen. So both are required, corpus or the body as well as animus or the mind. The JRF says that possession is a connection between an individual and a thing, which shows that an individual has an exceptional of having that thing and has the limit of arranging of. So this we have already discussed, that if I have this pen, then there is a relationship which is established between me and this pen. I am the owner of this pen, and this pen is the subject or the object of ownership. So this is what this philosopher JRF has to tell. Then next is what Savigny has to tell. In his hypothesis of possession, says that the pit of physical possession is to be found in the physical intensity of rejection. The first is corpus, for example, is the physical capacity to have a thing out of the blue. Marked by possession is the assurance to practice physical authority over a thing, all our own benefit combined with the ability to do as such. So according to Mark also, one should have physical authority over that thing, and according to Savigny also, physical intensity is the prior condition of having a possession. Main characterizes possession as physical confinement combined with the goal to hold the thing kept as one's own. So I can actually confine this, and I can put this pen in the cupboard, or I can write with it, or I can put my pen in the bag, or I can just put it on a table. So it depends on me that how should I physically confine the thing I possess. Kant characterizes possession and says that there must be an observational reality of taking possession conjoined with the will to have an outer item as one's own. At the end of the day, there are two elements which are basic to establish the idea of possession as complete and legitimate. They are as follows: the physical element, which comprises of physical commands over the thing, and the mental element, which comprises assurance to practice that control. So this we have already discussed, that there are two essential elements in possession. One is animus, which is the mind. The second is corpus, that is the physical possession of the thing in question. So we should have both physical element as well as mental element in order to possess a thing. Theory of possession by different scholars. Savigny theory of possession. Savigny, based on the content of Roman Justice Paul, said there are two elements of possession: corpus possessions, commonly known as corpus, and animus domini, known as animus. By corpus is implied a compelling physical control of that object, which I have explained. Animus basically means the mental element, or the aim to hold the possession as proprietor against all others. In simple words, it is a cognizant aim to avoid others from the objective aim of possession. Without the mental element, there can be no possession. So when I own this pen, I have the mental element in my mind that I am only the owner of the pen, and I should not give my pen away or keep my pen in public because I am the owner. Thus I have the mental element of excluding others from the possession of the particular pen. Herring's theory of possession. He stated that whatever point an individual resembles a proprietor in connection to a thing he has possession can't be denied to him except if by principles of law in light of useful comfort. So, when I possess something, I have actually become the proprietor or the possessor of the property in question. So, by law, I will have all the right to possess that property, but the law can also forbid me in possession of that property in case I do some illegal act on that property, or in case I do some business which is not authorized on that property. So the law can actually make me go away and can actually prohibit me from having possession of over that property on which I am engaged in the aforesaid acts. So I am owner or I am the possessor of the property, but by law can forbid me from enjoying or possessing my property. Accept the principles of law. According to Herring, what is vital is the consciousness of the thing which can offer possession to the individual. Holmes' theory. What establishes possession can be best concentrated just when possession is first picked up. He furthermore stated that to pick up possession, that at that point a man must remain in specific physical connection to the item, what's more, to the remainder of the world, and must have a specific plan. So what Holmes has to tell about possession? Let us consider an example. He talks about the physical connection to the item. So let us assume that I have bought a piece of land or 1 BHK apartment worth rupees 20 lakhs from a person, and I have paid all the amount, and I have signed on the deed also, and also I have got the keys, but I will not be considered the possessor of that land till I do not go physically into that land. So in this case, physical connection between the item and the owner is very necessary in order to become a valid possessor of a particular thing. So physical connection is laid emphasis by Holmes' theory. Bullock's theory of possession. In common speech, a man is said to have or to be in possession of anything which he has a clear control, or from the utilization of which has the evident intensity of excluding others. From the above mentioned clearly, Paulo played pressure not on hostility, yet accepted control which is defined physical control. So consider an example in which I am not the owner of the land, but I am only the possessor of the land because I have taken the land on rent or on lease for 1 year, and I have to pay the approximately 10,000 rupees every month in order to have possession on that land, and I have not paid the money from the last 4 months. So can the owner take all my things away, and can the owner break the lock of my apartment and put all the things outside? So he can do that because I am not paying his bills. So I cannot actually force the owner or turn hostile, and I should honor all the agreements which are related to possession. So if the owner and if the society accepts me, then only I will be considered as the possessor of that land, and I can't engage in quarrel without paying bills in order to get possession over that property. So now let us consider some questions related to legal rights and duties, ownership and possession. A legal person is any subject matter other than a human being to which law attributes. Personality is a statement given by. So in the previous class we have discussed about the definitions of persons given by various proponents. So This statement has been given by a very famous jurist, which is Salmond. Liability has been defined as the bond of necessity that exists between the wrongdoer and the remedy of the wrong is set by. So there is a right and there is a liability. If a person has the right, then B, C, D will have liability to follow that right, and if B, C, D do not follow that right, that liability, then A will have the right over B, C, D in accordance to that performance. So this bond of necessity that exists between the wrongdoer and the remedy has been also given by Salmond. Possession through an agent for servant is example of. So the answer is mediate possession. Possession through agent. Let us take an example. Consider that I have a property named as Y property, and I have 4 properties named as X, Y, Z and B, and I have gone to a broker and told him that you have to put the properties X, Y, Z and B on rent. So the broker has agreed for the same, and I have given him the keys of that property. So in this case, what will be the situation? The situation is that the broker here is the agent. So the persons who are taking getting that property on rent, that is getting the property X, Y, Z, B on rent, or having possession of X, Y, Z property, is via agent. So in this case it is called as mediate possession. Which one of the following are 2 main theories of legal rights? So we have discussed about various theories of legal rights: interest theory, will theory, etc. So the answer to this question is realistic and will theory. Assertion: a legal right is a legally protected interest, reason, an element of advantage is essential to constitute right. So if a person has advantage over something, then he has the right over that thing, because liability is always negative and right always comes with advantage. So this statement is correct, but a legal right is a legally protected interest is not correct, because we have seen in our previous classes that every legal right does not come with legal protected interest. Some legal rights are so ambiguous because of the conflicts in the society that one is not able to have the legal right. So in cases when there is a conflict with regard to religion, or with regard to job opportunities, or with regard to the equal pay for between different genders, so in this case they have a legal right, but in some conditions their legal right may not be protected. So the answer to this question is R is right but A is wrong. Ownership denotes the relationship between a person and an object forming the subject matter of his ownership. This observation was given by, so owner versus object relationship has been given by Holland. The most important power of owner is the right to exclude others. Owner may grant to other many of his rights and yet remains the owner. So I think both the options are correct. Read both the options. Owner is the right to exclude others. So if I am the owner of the property, I have right that I can actually lock the door before I go anywhere, so that others are not able to enter my property. So I have excluded others in getting possession or ownership over my property. So this is right, and owner may grant to other many of his rights and yet remains the owner. So of course, because owner can grant the right to possession, the right to carry some business, or the right to carry an office in his building, and yet he remains the owner because he has transferred only some of his rights to other party but not the ownership rights. So both are correct. This assertion A and R, and select the correct code below. Assertion A, claim to recover a debt barred by lapse of time is an imperfect right. So we have discussed the various rights, and which I have told you the perfect right is available and one is able to enforce a perfect right. But in the case of imperfect right, because of some conditions like time barredness of a particular debt or different examples can be related to that right is not enforceable, then it is an imperfect right. So in this case, time barred lapse of debt barred by time lapse is an imperfect right. The statute of limitation does not provide that after a certain time that shall be extinct. So both the options are correct. So the answer to this question will be A. A person in possession of a thing is deemed to be a owner of thing possessed. Possession is good as ownership. This statement is not correct because possession and ownership are two different concepts, and a person in possession of a thing is deemed to be owner of thing possessed. This is a right statement. Both A is right but R is wrong. Assertion: shareholders are not in the eyes of law part owners of the company. The company is something different from the totality of shareholders. So shareholders are considered the part of the company because they actually have invested in the company along with the board of directors. So shareholders are considered as the part of the company according to company law. Shareholders are collective owners of the company. Shareholders are not the collective owners of the company. Other than shareholders, the board of directors are also considered as owners of the company. So the answer to this question will be A is right and R is wrong. So answer is C. The statement equitable ownership of a legal right is different from the ownership of an equitable right shows that law and equity differs with regard to. So here it is talking about equitable ownership of a legal right. So here it is talking about ownership, and ownership of equitable right here is talking about existence. Here it is talking about existence, and here it is talking about ownership of the equitable right. So we have discussed what is equitable right. Equitable right means that good conscience, right with regard to good conscience, right with regard to principles of natural justice, etc. So in this case, both existence and ownership of right is talked about, so the answer is C. So this is all which we have discussed till now. Today we have discussed about possession as well as ownership, and also the previous year's questions, about 10 questions which have come related to right, duties, ownership and possession. So next class we will continue our topic further with regard to the possession of property. Till then, bye and take care.